Patty mentioned, name is Alex. Pleasure to meet everybody. I'll do a little bit of an intro and kind of tell you why is it so that I'm speaking with you here. But first we're gonna cover a little bit of what it is that we're gonna be discussing here, right? So I wanted to make sure, and in these things, right, in the speaking engagements, presentations, I always feel like there is a lot of value in having the interactive format, right? The majority of the value that I provide is educational in nature, and it's knowledge is my product, my service, right? So when it comes to these presentations, I like to make sure that I provide everybody with a basic understanding. And I do understand that a lot of the folks already know, you are artists, you are creators, some of those things that I'm going to be talking about when it comes to copyrights, trademarks, patents, trade secrets, licensing, and obviously AI and blockchain that we're going to be touching on. So, even though I want to make sure that we cover the basics, and after that I'll leave the floor to the questions, both the ones if you submitted via forms that we have here in the chat, and also just the ones that you gonna have come up while I'm speaking. So feel free to at any point put notes down, write things that would be prevalent and important to your projects and your careers and your business endeavors and your creative endeavors as I'm going through the topics. And then I want to make sure to leave, at least about half of the time slot that we have dedicated today to, delve into those specific scenarios and help you guys out. So I was a little bit of myself, right? So to do a little bit of a self intro, I've been an attorney for about 11 years now. Out of those 11, 6 have been in the U.S. I have a degree in sports law. I have a degree in intellectual property, media, information law out of Brooklyn Law School in Barden, New York. I've been working in Miami since 2018 for the current law firm. We are a boutique law firm. We have about 6 lawyers, and we deal with a bunch of different matters. We have a lot of representation in the music space, with labels and projects and individual artists, independent artists, artists who are looking to get signed to labels and distro companies, looking to get their catalog sold. We work with just visual artists, graffiti artists, comic artists. We work with a bunch of different fashion brands and e-commerce projects, as well as tech startups and Web3 projects as well. And regarding to the Web3 space, I've been in the space for about 4 years, ever since the last cycle, and being in Miami, just it's a matter of attending conferences, and there's a lot of different content and projects and people looking to build things in Web3. So I've had a pleasure of working with a lot of them and helping them kind of navigate the legalities of the process. When it comes to AI, I've also had a couple of 2, 3, 4, 5 clients over the past year alone, whether providing AI services in a SaaS format or providing AI services to high-ticket clients, so using AI as kind of the building block for their apps and web apps, and had a pleasure of helping them out as well. So let's start off, right? So one of the things that we kind of need to cover when we talk about IP is the different versions thereof, right? Intellectual property is generally protected on a federal level, right, by the federal government, and there are a certain number of different categories of IP that apply to both businesses and creatives, depending on what it is that they're set up to do. And you can see those at the screen. Those would be the copyright, right, that protects any type of creative expressions that you do, your music, your art, your paintings, your literary works, your poems, and anything in between. Then there would be trademarks, and the trademarks is the intellectual property that covers your pseudonyms and names and brand names and logos, something that identifies your services when you are using your name in commerce, right? So whenever you think of trademarks, we're thinking about McDonald's and Apple's and all of those brands that we know and that we identify in relation to the services that they provide. Patents would be, in relation to the different inventions and different products that we create that would be novel and useful. And full disclaimer here, I don't necessarily practice patent law. We do a lot of work in copyrights and trademarks and trade secrets and personality rights. Patent law requires an additional, bar registration and with a patent bar, and requiring an additional, engineering STEM mathematical degree, which I do not hold. So I'm going to generally provide you with a certain outline of the interrelation between patents and trade secrets that, I've found some startups and tech projects that come through my doors utilize when we refer them to, our patent law partners. But everything else is, something that we practice on a daily basis. So let's get into it, right? So copyrights. As mentioned, copyrights generally protects the things that you create. So the original official, definition is protects the works of authorships that are fixed in a tangible medium of expression. So what is it, the fixed in a tangible medium of expression? What does that mouthful stand for, right? That means that in order for something to be protected by copyright, and the copyright protection vests with the author the moment he creates something and he puts it out for other people to see, right? So if you are walking down the street and you have a melody in your head and you're humming it to yourself, that wouldn't be protected by copyright. But the moment you record it into a microphone and have an MP3 file that somebody can listen to, that would be that tangible medium of expression, right? And obviously, in regards to copyrights, that particular works need to be original. If you're singing a Titanic theme song into a microphone, you need to obtain a license from the owners to monetize. Now, that originality is not necessarily the high bar of a criteria, and this is one of those things that I usually tell my clients who, require my assistance with a variety of different things, is that there are some things that you don't need a lawyer for. And, simple copyright registrations, when we don't talk about, multiple owners, different owners of the, different types of copyrights associated with one work, like with music. If we're talking about something as simple as, I have an image and I want to register it and register the copyrights to it, you can always do that yourselves through a copyright.gov website. Get yourself a login password there, register, go through the application, answer the questions, identify who the authors are and when the work was published and whether it's unpublished or not. And then, within 2-3 months, you'll have your copyright registration certificate. Now, the registration element is important because, with a lot of these, namely copyrights and trademarks, right, and trade secrets as well, there's not necessarily a need for registration for you to have the rights, but there is a need for registration for you to obtain additional benefits. In case of a copyright, without copyright registration, so without going to copyright.gov and registering your, copyrights to your work, you won't be able to go to court. You won't be able to obtain additional damages. You won't be able to obtain attorney fees from somebody who is, stealing your work, monetizing it, and, trying to get away with it. And and one of the other things is, in terms of the length of the, ownership of the rights, as, the slide says, right, it's usually life of author plus 70 years, but there are some additional scenarios like a work for hire scenario. It's an important one because whenever you work with somebody, right, whenever you have somebody create something for you, you have a designer develop your logo, you have a web developer develop your website, because code is also that creative expression that can be protected by copyright. You need to make sure that you have a written document between yourself and that individual that stipulates for the work for hire, being part of that relationship, because work for hire means I pay you, you create, but I own. And it's important because whenever you see agreements that assign something to you, like a web development agreement where it says, we're gonna create it. The developers say we're gonna create this software, and then we're gonna assign it to you when you pay us. One important caveat there is that the copyright provides for a reversion right after 35 years from the original assignment to license. So even if you have a perpetual license granted to somebody, right, or rather, if you have received a perpetual license, or if you received an assignment 35 years down the road, that person can go to the copyright office, issue a notice of reversion, and get the rights back. If you are doing it on a work for hire basis, that means that you are, as the person who pays for the specific work being created, an owner from the beginning of the work's creation. So that person who creates the work is not even in the chain of title, meaning that there's no way for somebody to reverse something if they are not even included in the creation process, because it's a work for hire. So just take it into account. You generally need a work for hire agreement whenever you're hiring somebody to create something expressive for you. Now, trademarks. So with trademarks, there's a couple of different elements, and When it comes to trademarks, I generally wouldn't recommend you registering those yourselves, because I've had a number of clients, or people who have later become clients, try to do things themselves, and I have not, maybe other than 2 or 3 instances, have not had a single instance of somebody successfully doing so. And not because this is something that requires Mensa intelligence. It's a very specific process that has its own legal and practical, like when you're filling out the application, clauses and provisions and specific fields that just need to be operated in a certain format in order for you to obtain that application, to go through the registration. But generally speaking, same with the copyrights. The moment you start using the name of your business, your pseudonym, your nickname, anything artistic, right, that you identify as, in commerce, meaning people start purchasing goods from you, services from you, on whatever subscription, payment plan, individual purchase basis, whatever the case may be, then you have the rights to that trademark. But those rights would be common law rights that wouldn't provide you with that full scope of protection. But for instance, if you have started, to use the name, like, what do we have here? Mannix, let's say, right? We have a name Mannix that we're using for apparel, and we haven't done a registration. If somebody else who similarly hasn't done registration started doing it first, they can go to court against you. You don't need a trademark registration to go to court. You can do it on the basis of common law rights, and claim that you're infringing on their intellectual property because they were there first. So by default, trademarks are granted a certain level of protection even without registration. However, if you do have a registration, that provides you with a priority of the name of that mark over the whole country. The federal trademark registration would do. Don't ever register state registrations. That costs about 1/3 of the price of a federal one, and it covers 1/50th of the scope of the protection. So just why do you do that? Just go to the federal one. And once you obtain the trademark registration, you obtain additional rights like additional damages, priority, presumption of your ownership in court, ability to get extra damages, ability to get extra attorney fees from the potential infringers. Now, if you look at the slide, the distinctive, non-descriptive, and the use in commerce, right? These are very important elements. The first one is kind of self-explanatory. It's just like it needs to be something different than what everybody else is using in regards to the same types of goods and services. And this is where that element of likelihood of confusion comes in, meaning that if you have a mark that's relating to a specific set of goods or services, and you have found somebody using a similar mark in relation to the similar goods and services, then you can file, a trademark litigation against them, send them a demand letter. You can ask them to cease their infringing activity. And when you do the trademark registration process, the United States Trademark and Patent Office also similarly, Patent and Trademark Office similarly performs that analysis. It's called the trademark clearance, meaning this is something that you can do by going to TESS, TESS, the Trademark Electronic Search System, and see if the name that you want to register is already registered. But once again, if somebody uses the name for baking goods and you want to start doing racing car engines, you're good to go, because the trademark protects specific names within the specific class of goods. Now, the non-descriptive element is something that a lot of founders, projects, artists don't necessarily take into account. We've had some clients come through the doors and say like, "Oh, I've just registered the domain name. This is going to be so awesome for the SEO because it says exactly what I'm going to be doing." It's like, "Oh, apartmentcleaningservices.com," which is awesome. And probably those domain names are the most expensive ones because they're so good for the SEO and your searchability. But unfortunately, if you can understand as a consumer what the service is by looking at the trademark, you're likely not going to be able to register it. Take Apple, for example. Apple was able to register its mark in regards to computers because when we look at Apple, we don't think, smartphones. However, if somebody tried to register the word Apple to sell apple juice, they would be prevented from doing so because that would be descriptive of the services, and that would prevent every other seller of apples, apple juice, whatever the case may be, from just advertising their services, because then you would be able to send a demand letter to them and say, "Oh, stop doing it, you're using my trademark." So in that instance, it's important to have a separation between your name and your brand and the services that you're doing. The closer they are together, the more likely they are to consider to be generic, meaning completely unregisterable, or descriptive, which descriptive marks can be registered and have a secondary meaning, meaning that, oh yeah, your mark has been around for 50 years and everybody knows it, and now when everybody looks at it, despite the fact that it is a little bit descriptive of what you do, it still creates an impression that those goods are associated with you because you have spent millions of dollars and have been in the market for however many years. So those instances are usually just hard to defend unless you have that separation between the brand and the services. And the use in commerce is relatively self-explanatory, but it also speaks a little bit to what kinds of marks you can apply for, or like how can you apply for your marks. You can always apply for a mark saying that you are already using it in commerce, the use in commerce application, where you provide proof that you have started using the mark accordingly. Or alternatively, you can apply for an intent to use mark, meaning I want to start using that name. You obtain a certain reservation of that name, and then within the scope of 3 years, after your application goes through the USPTO's master, you need to submit that proof of use. You have 5-6 months periods to do that. Each additional extension costs additional $100, and that's pretty much is the way for the government to protect people from somebody reserving the name forever. Once you've applied for intent to use, you have a specific period of time to start using it, or the mark becomes abandoned. Now, in regards to the length of ownership, trademarks are pretty cool in that as long as you continue using the mark in commerce and you continue filing every 5 to 10 years that you are continuing to use the mark, then you maintain that ownership of that specific insignia, whether it be a logo, a word, or a design. And we can go into it a little bit deeper if you have any more specific questions in the Q&A session. Now, let's talk a little bit about patents and trade secrets. I'm going to be talking about them a little bit jointly, so to speak. So we know that patents cover inventions, right? Cover things that are novel, not obvious, that are useful, meaning that usually when we think of patents, we think like, oh, a physical product, a physical good, right? It can be a software patent as well. It can be a biomedical patent. And patents are extremely strong in terms of the exclusivity that they provide you with. You can have the rights to use this particular technology that you've invented and patented for the duration of 20 years, right? And then it becomes part of public domain, meaning everybody can use it. That is part of the general intellectual property kind of concept has been instituted by the Constitution, right? And it is meant to incentivize people to create. It's meant to incentivize artists to create art, to inspire us to make derivative works, to be inspired by either art and create something new that pushes the culture forward. It inspires or incentivizes the inventors of changing our lives by creating things that forever change the way how we process information, get from place to place, etc. And in cases of trademarks, obviously it motivates and incentivizes businesses to continue creating value and adding value via their goods and services. Now, how trade secrets and patents kind of go hand in hand in some processes is that trade secrets, they're not registrable. There's nowhere where you can go and register your trade secrets, right? And trade secrets get, you get the trade secret protection if you have some certain, process or practice, formula that you are using in your business, that has the value in it being unknown to people, right? So you have found a way to process customer calls in 6 seconds, as opposed to the 30 minutes that it takes everybody else. You have done it through, using 6 different AI technologies and 5 different, CRM softwares and whatnot. And you have merged them together with Zapier and Make.com in a way that allow you to have this perfect functioning system. Now, can you protect any of this, like with copyright? No, because you're using somebody else's software, right? You don't own any of this, but you can obtain, you can get the protection of a trade secret over a specific process if you maintain its secrecy, right? So if you have a trade secret policy in your company, if you have an NDA with every single vendor that has access to this process, every single employee, which allows you to have a certain level of protection in case your employee leaves your company and goes to a competitor, and now starts, to start sharing those secrets with a competitor, leading to them trying to implement that particular process, right? This is where the United States, Trade Secret Act comes into play, Uniform Trade Secret Act, that allows you to, get an injunction against an employer or, competitor who has poached your employee and now is trying to reinstate the process that you have obtained, kind of independently and have kept secret. Now, secret is very important, right? If you have that process be up online on your website, you're not going to be able to claim trade secret here. But the benefit of it is once you install those internal processes, you don't need to go to somebody to disclose this, to register it. It's just a given right that you have under the Trade Secret Act. Now, how do the trade secrets and patents come together? The thing is that not everything is patentable, right? There is certain criteria for what can be patentable. And then secondly, during the patentability process, the registration process, you need to disclose, right? And say, well, this is exactly what it is that I want patent. And in such instances, why a lot of the founders have gone away from software patents is that they're not very likely to go through in some instances. And you cannot disclosing your secret juice to the rest of the competition because they can go online and look it up. So this is where trade secrets, they have some benefit when they're being used conjunctively together with the patents. For instance, when you're keeping that trade secret until you are at the stage where you get the patent, right? And now you don't have to keep the trade secret because you have exclusivity. Now, obviously, patents are much stronger than trade secrets because you go through the process. You have the government verify that this is indeed novel and unique, and they give you that exclusivity for 20 years. While with trade secrets, if you are keeping everything secret, you have an amazing process, but somebody else has independently developed that process without ever stealing any information from you, then you can't really do anything. And if after that they have also went and got a patent on that process, then now they have the exclusive rights, despite the fact that you were earlier, that you've created this independently. So this is where the founders need to make sure that they kind of use those two things, kind of jointly, depending on what it is that they're trying to protect. So it's just a couple of my 5 cents regarding the kind of interoperability between trade secrets and patents. Licensing. So licensing is something that is very, very, near and dear to my heart. This is, where I started my legal profession, working for, a cartoon brand that has been, licensing throughout, 200 countries, its content for different merchandise and media rights. And, that's the majority of kind of revenue sources for creators oftentimes, or intellectual property owners, when it comes to, holding your IP. If you have IP, whether it be copyright, you have music and you want to, you're a producer who wants to license the beat and get royalties back, right? Or have has received funds for it and then receive a royalty on the back end, that's licensing, right? If you are an artist, a visual artist who wants to have, a product manufacturer create pens and, cups and backpacks and shoes using your IP, you are licensing your IP, right? And in a lot of the scenarios, when you're an owner of IP and your business is IP dependent, licensing is the way how you're going to get paid, because that is kind of the general way to provide other people with permission to use your IP. Now, here, this slide kind of covers some of the basics that everybody should take into account whenever they go into those conversations for licensing, their intellectual property. And that would be, the scope. And the scope, when we talk about licensing, there's usually 2 parts, right? Multiple can be involved as well. But generally, it's the licensor, the holder of the rights, and the licensee, the person who received the permission to use the rights to do whatever the case may be, right? Somehow monetize. Now, the scope determines what it is exactly that we're licensing. We don't want, if we have, a set of rights, let's say we have an amazing comic book, right, that we wrote and everybody loves. We don't want to go and give, a counterparty that is really good at printing T-shirts your full scope of rights into that property, right? You want to give them the right to print T-shirts. Then you want to make sure that you maintain your right to do backpacks and do apparel and do this and that. Create an NFT and have it be distributed via commercial license, right? So with in those instances, scope determines how much do you have left once you've performed that license. And obviously, your license can be exclusive and can be non-exclusive. It can have the rights to sub-license. It cannot have those rights. But at the end of the day, it's the goal of the licensor to give the licensee as little as possible, and it's the goal of the licensee to get as much as possible from the licensor. And same applies to all of the other kind of main elements of a licensing deal that you see in front of you. It's territory, right? It doesn't make sense for me to provide licensing to an agent that is US based, has US connections and US brands, to give them the rights to the whole world, right? Because maybe there's another agent in Europe and France and Germany and Netherlands that has more specific connections, values, and can get me a better output in terms of royalties on the back end when it comes to monetization on this specific territory. So as a licensor, as a holder of rights, your goal is to be as niche, as specific as possible, unless, of course, somebody makes you an offer that you can't refuse, and you see that there's a value in giving such a broad license because, now you're going to Disney, right? And we better have worldwide rights because they have access everywhere and they're going to be selling your stuff everywhere. Okay, that makes sense. But if you're working with a local, licensee agent, master agent, it doesn't make sense to provide them with a full scope or the full world territory, or how those licensing agreements usually state the universe. Now, the terms, the royalties, the obligations, right? All of that is relatively self-explanatory, but it is important because in a lot of scenarios, especially when it comes to different music licenses that we execute, folks oftentimes just don't look at those things. People look at the advances that they are about to get and the the royalties, the splits, and all of that is cool and nice, but it would be, there's always a negotiation to be had about how long will the licensee have those rights. And the shorter term deals that you execute, the more leverage you have moving forward. And in some instances, it makes sense to execute a longer term deal, even as a licensor, because you really trust that partner, because you've already tested them out with a couple of short licensing periods, and then you know that they're the company to actually get the most value from your property. So it doesn't really make sense for you to go somewhere else. Yes, sure, execute a license for a longer term. However, if you have an ability to license it for a 1-year term, and let's say they want an option to extend it for a larger term for another 1-year period, okay, you can give them that option, but you can also implement some milestones that would require them to be completed right by the licensee, certain monetary considerations, right, connections, brand partnerships executed, etc., in order for them to obtain that right to get that second period. It's just about, once again, licensors wanting to retain as much as possible, licensees wanting to get as much as possible. Royalties, and royalties depend on oftentimes the specific piece of work that we are licensing. For instance, when we talk about music, then there is usually a composition and there's a sound recording. There's 15 different royalty collecting organizations, each one of them collecting a different portion from each individual piece of the work, which is suboptimal, which is something that some of our newer technologies can potentially resolve down the road, but not necessarily something that has been resolved yet, because of how just the music industry is composed. And there's just this long 50, 60, 70-year-old tradition, so to say, and control in the hands of publishers and record labels and royalty collecting organizations that make the system work a little bit less optimal than you would otherwise have it be. Obviously, when it comes to the blockchain and all the new talk of the town, there was something that I spoke about on the NFT NYC the other month regarding royalties and NFTs, right? And this is, NFTs is a very good way for independent artists to potentially monetize their fan base and their following. And when somebody purchases your NFT, your NFT costs you nothing to create, right? You don't need to print any merch, you don't need to pay any production costs. You just go to a creator, an NFT marketplace and create an NFT or upload your NFT onto it and get connected to the smart contract, and then you launch it in the marketplace, and then you have an ability to sell it. So the margin, the actual margin of potential returns can be very high, but it also depends on how good your fan base is. And in the perfect world down the road, there will be an ability to do interchain operability and intra-platform operability that is not in place right now. So those secondary royalties, right, that a lot of the conversations are about when it comes to NFTs, are not always necessarily available to folks, just because there's not necessarily a proper protocol in place whenever you change, you have a Solana NFT and you move it from OpenSea, the Magic Eden to OpenSea, like there's going to be an interoperability issue and a transferability issue. And even if you go to those platforms, they even allow, the purchasers of your work to select whether they're going to be paying secondary royalties, right? So that's just something that hopefully technology allows us to change moving forward. The last element is just something that I wanted to mention regarding obligations, and this is where you want to make sure that you control the way in which people are utilizing your IP as a licensor. Because when it comes to trademarks, for instance, right, if you come to a McDonald's, and the McDonald's M is not fluid and it's actually a slanted one, and the burgers do not look like they should be looking, and everything is, a little bit messed up, then you're going to have issues with the quality of the product, right? You're going to see, is that really McDonald's? Has it got some rinky-dink thing? And that's a problem. If you don't, as a licensor, which franchisors, are usually licensing their trademarks to franchisees, when you license your trademarks, and to some extent it applies to copyrights as well, you need to maintain certain control over how it is utilized, how it is sub-licensed, how it is implemented, or you risk having those rights be rescinded because you're not controlling the quality of the goods sold under your specific trademark, and your trademark can be abandoned. So those are some of just things that I wanted to mention. And obviously, there's a bunch of different things that go into a 25-page licensing agreement with limitations of liability and representations, notifications, different audit provisions allowing licensors to look at the licensee's books and things of that nature. But at the end of the day, it's just making sure that you have an agreement that makes sense and that is in line with your business strategy and the available options that you have on the table. So, and this is, a part of my job, obviously. Now, technology, right? And I'm gonna, speed up a little bit here because I wanted to make sure that I have a chance to answer any questions that we have. We wanted to chat a little bit about AI and blockchain, right? And so, how can creators benefit from AI? I think there's a variety of different ways. Look, obviously, there's a content creation element. I would say a significant portion of this presentation has been created using AI because that's just very convenient to do so upon the proper prompt. The rights management element is interesting because the ability of AI to go through databases, to search specific metadata, to identify specific infringements is potentially very helpful. However, there has been a number of different research that's shown that digital rights management platforms that have been using algorithms, which is kind of like the basic format of AI, which has been around for decades. Like the YouTube content the content ID system, right? This is where there has been research in regards to it not necessarily being as efficient and oftentimes making mistakes in regards to whether something is an infringement or not. But at the very least, AI can definitely increase the speed of processing and allow you to know whether anybody else out there on the web is utilizing your intellectual property. And I have a number of different tools that could be helpful in that process, and a bunch of different brand companies have been using those for ions before ChatGPT ever come about, and now they're just becoming a little bit more efficient. And data analysis, obviously, same thing when it comes to any analysis of massive data. When it comes to, let's say, you can go to Amazon and you can install an extension that allows you to see what products are the most trending, what products have been trending for the past day, hour, week, etc., and kind of see where those trends go and what are some of the things that people are buying, to allow yourself to have a little bit more information and be more educated as to which products should you, or which product manufacturers should you license your IP to in order to get the most benefit. That's also part of that equation that AI can help you out with. And I'm sure there's going to be a couple of questions regarding content creation and AI and which one of those is copyrightable. And actually there has been a submission before the House of the Representatives on the Intellectual Property Commission, detailing that yesterday, where a Georgetown law professor has kind of broken some things down in regards to her general perspective is that the existing framework is capable of dealing with AI questions, and the same way how it was capable of dealing with peer-to-peer sharing and digitizing books and a Napster and streaming. So there's been a lot of disruptive technology, so to say, but thankfully the laws, the law is an evolving thing, although, definitely slow in some instances, but it has had the frameworks that are capable of dealing with either blockchain questions or AI questions, even though some things definitely will need to be kind of adjusted in regards to our approach as the technology develops. But there's a lot of different interesting thought processes in that, and I'm happy to discuss that further. When it comes to blockchain, this is an interesting topic because I think it's a tool at the end of the day, and as I mentioned, I've been in the space for about 4 years, and when it first started, so to say, first reached my desk, there was a lot of nonsense, mature, not mature, right, immature projects that were claiming to, we're going to do an NFT and maybe print some T-shirts, give us $200 million, right? And then, surprise, surprise, I actually got $200 million, right, during the raise of the bull market in 2021. But what I see now is a lot of projects that are either connected to quality development or quality solutions or quality real life assets. And this is where smart contracts can automate, this smart contract is, it is what it sounds like. It allows you to implement certain procedures and certain rules that will be automatically executable without human interaction, human involvement. Proof of ownership obviously plays a significant role when it comes to intellectual property rights. Currently have a client who's doing a lot of good work in authentication of different assets, both digital and physical ones. And this is just to speak, to existing markets that are already in place, the markets for sport cards and the different paraphernalia that gets value from it being authentic and from it coming from a specific source, and the ability of blockchain to provide you with that additional evidence and proof of ownership is definitely valuable. And obviously the royalty distribution, which, as I mentioned, is not perfect yet. There hasn't been no perfect protocol that allows automatic distribution down the chain, down the kind of family tree of all contributors to specific work. And there's been a bunch of different, science papers that have dealt with, how do we fix, for instance, the music industry, and how do we make sure that the different composers and producers and collaborators all get equally paid, or properly paid, fairly paid, equitably paid at proper times automatically, without the need for 17 intermediaries, without the need for me to go to the royalty collecting organization that's going to collect it from a streaming service, that's going to collect it from a distributor, right? Without jumping through those hoops and at every stage risking human error and malice as well at some instances, because you'd be very surprised by that. But yeah, a lot of labels are very bad at accounting for the dollars to their artists. So with that in mind, I wanted to leave some time for practical questions for you guys, both for the ones that you've put together before the class or before the webinar, as well as the ones that you have kind of come up with throughout. And I'm happy to give the floor to Patty to read out some of those for us and see whether I'll be able to assist you here on the spot. And if I won't be able to, because some of those, unfortunately, we're going to have the answer of it depends. And then if that is the case, then you're free to reach out to me using any of the contact information that you see on the page. Use the QR code and schedule a consultation so we can have a one-on-one conversation. I usually like to keep my doors open and don't charge for consultation. So feel free to schedule a slot for us to chat a little bit more in depth.
Thank you so much, Alex. It's very comprehensive. Definitely cover a lot of topics, and it's a really great job, because I think in the beginning we said, okay, it's really a lot, but you covered, I think, all the basics. While we're waiting for more questions from our group, from the group today, I want you Alex to help answer some questions we already collected during the registration process. So there is one creator ask, can we protect things we previously put online before copyrighting them?
So there's a couple of points to this. Well, A, as mentioned, you have protection per se, right? You have ownership in something the moment you create it. If you create it by putting it on a piece of napkin, then that is the time when you create it, and that's the moment from which you are an owner, right? Then obviously, if your creation comes in a digital format, and the first time you see something is when you create it in Photoshop, okay, wonderful. That's the time for your creation. Now, the protection will apply to you. Now, the question is not necessarily protection. The question is enforcement, because the moment you see somebody, infringing on your intellectual property and using it and stealing it and, somehow monetizing it, you have a practical question of how do I stop them from doing so? And if you reach out to somebody and you say like, oh, I own this, give me my money, all of that, and you don't have copyright registration, which is not needed for you to be an author, but is very much needed for you to bring a case in court, then if the other side has an attorney, they're just going to say, well, you don't even have copyright registration. You can't sue us. Like, why would we even be negotiating with you? So there is an additional element of protection that you obtain through registration. And, the registration gives you a couple of benefits, as we mentioned, the additional damages, having the other side pay your lawyer fees, having statutory damages in the form of 150K for willful infringement per work. And then your ability to go to court generally as well. So in regards to the timing of things, right? It's usually an element. There's an element of you want to be as fast as possible, but also within reason in terms of your budgeting consideration. Like if you're a musician and you have 140 songs and 3 of them are making you money, probably makes sense to register those, not the other 137, right? And in terms of timing, if you register your works before they were published, or within 3 months after they've been infringed on, then you have a right to, to obtain those additional statutory damages. So the moment you see somebody has infringed your IP, get a copyright registered, and then you're gonna have a better case when you're trying to settle it outside of court, because court is goddamn expensive, and you don't want to go to court unless you have, hundreds of thousands of dollars, and you just want to, kind of show the other party some bad time. So yeah. I would definitely recommend doing a registration if you want to pursue any infringement action.
Great advice. We got another question from our audience today from Amy. Amy is asking, what are the primary organizations that govern IP law and practice in the US? And, whether they're providing adequate guidance regarding today's creator to consumer economy, infected by the Web3, AI, and all those tech? Are they doing something regarding it?
Yeah, there's a multi. So IP is not one thing, right? There's a copyright office that governs the copyright matters. That's the one which you go to register your copyrights. There's the United States Patents and Trademark Office that you go to register your trademarks and patents respectively. Trade secrets, you don't need a registration. You just need to maintain that secretive regime with contracts within your company. There's, if we're talking about e-commerce, there's a bunch of different, kind of regulative authorities like FTC, the Federal Trade Commission, that regulates those. As well as when it comes to Web3, it depends on what your business is, right? If your business is a payment system, right, a payment rail system, on-ramp, off-ramp, you're going to need a money service business license from FinCEN. If you are trying to do an ICO, initial coin offering, and you're trying to, launch it in the US and raise money from US investors, retail investors, then the SEC is going to be, the Securities Exchange Commission is going to be very interested by this activity. So there's not a single body that governs, and there's definitely a lot of guidance, right? If you go and look, a lot of those agencies are regularly releasing both video as well as, written format kind of guidances to, what is the good way for you to operate this particular entity. Like right now, I was just reading a, let me see, a specific DAO kind of pamphlet from, let me see, who was that? The World Economic Forum, that was, right? So there's a bunch of different kind of entities, and you just need to look to quality authority, whether it be, a law firms, right? I mean, whether it be government agencies, whether it be, entities that are at the forefront of the actual business, CoinDesk and Coinbase, some of the ones that you can trust in terms of that information. There's a lot of, educational materials online as well, obviously, but there's not necessarily one place. And due to the fact that, just the question that you mentioned could potentially involve 3 or 4 regulating bodies, this is exactly where you go to an attorney and kind of have them go through your specific case with you, because depending on the, oh, am I doing this? Am I doing this? Am I advertising using those words? Am I trying to get money from those people? Am I providing that service? A bunch of different regulatory agencies could, be interested in that and have their own rules for how this should go.
Very, very thorough answer. We got another question from Tina, and Tina is asking whether fan art is protected by copyright or not.
Well, but if by fan art you mean, art that is inspired, right? When when I read fan art, right, I kind of think about literature for the most part, like, right, people looking at Harry Potter and then thinking like, oh, let me create a story where Harry Potter is actually a villain, right, or something like that. The thing is that there is, you can all obviously do that to an extent, but the moment you start commercializing it, this is where you try to verge on, you do infringe on copyright, because in order for somebody to use copyright and create copyright based on something that belongs to somebody else, they need to obtain a license. It's usually a license to create derivative works, right? Same with music. When somebody creates, a track and you want to do a deviation from it, a remix from it, you need to obtain a license from it to do it. Same with art, right? If you want to, obtain it, there is an element of fair use in it, obviously, because if you are, doing it for educational purposes, or you're doing it for news purposes, or there's enough transformative, use in it, meaning, you've taken somebody's work and then you've put it in a completely different medium of expression, and something that was, a painting before is now a glass mosaic, right? And it has an additional meaning to it, and there's an additional elements to it. There is a case to be made that that is fair use, but it's still, you can't. It's that balance where one side is going to be saying, well, yes, you might claim that that's fair use, but you're getting money for it. And the other side is going to try to say like, oh, no, this is actually, just the freedom of expression. And that is usually going to be resolved in court. So the safe kind of measure of things is, if you're trying to commercialize something using somebody else's IP, get a license or get a permission, right? Or alternatively, you use your own IP and develop that one. So that's kind of it depends answer.
Yeah, I think I heard that a lot, because recently there are some interesting case like on Andy Warhol's and foundation.
Yep.
I think they lost a suit, and so my suggestion, probably you guys should call Alex like for one-on-one consultation, just ask for specific advice on your occasion. So here is another question. I'm also curious about these days, if an artist create an image using an AI generator, but using my own artwork as a basis, for to create images, can I still copyright it? Because now I know, like, the government say like AI artwork is not being covered by the patent. Yeah.
Yeah, so it is copyright, not necessarily patent, but yeah, the corporate office has expressed something that is not new. It has been around for 40 years, is that the human element in original authorship and that intelligent original creativity, right, requires that human element. There was a case before where a monkey took a picture, taken somebody's, photographer's camera, and there was a case: can a monkey be an author within the meaning of copyright? And the court decided no, in the same way how they, corporate office has issued a memo stating that AI art is not considered to be copyrightable, because if the basis of Constitution providing people an ability to have those additional protections for their IP is to incentivize more creation, right? There's no point in incentivizing AI that cannot create by itself without being prompted. Thankfully so. Until now, until it's sentient. There's no point in incentivizing it by giving AI copyright, and this is where I can send an actual very interesting paper right on the topic. It's actually that commission that I mentioned with the House of Representatives. I'll send it via email later. I think I have like a PDF version. It's an opinion in regards to what is a good way to approach intellectual property and copyright with AI context. And the answer there is kind of like, what are some of the options? The option A is have AI be the copyright owner. It doesn't work. It's not a human. Nobody has ever done that. It doesn't make sense. What's the point of doing that? Get away from it. Now, the second option is, can the person and AI be co-authors? Once again, co-authorship presumes intelligent thinking, creative process, not part of AI. Now, can a work be registered if a portion of a work has been used, have been created using AI? And the answer to that is yes. And it also depends, but it also depends on the level of involvement, right? If the human said, make a picture of a cat in a hat, right? That's not very specific, right? That's just kind of like general idea, and ideas are not protected by copyright. If there was a 25 different sets of prompts after this, specifying, providing details, doing, specific, outlines of how you want this specific image to look, and then after AI has generated an image, you made an actual like outline of it and drew it by hand, despite the fact that AI created it, then in that instance, right, and then you put it in a mural that also is, has been created by you, and then once you're registering it, you are disclaiming the AI portion of it, then yes, you can definitely copyright it. But needs to be a little bit more practice for those specific questions. Like, I have my own artwork. I've, done some deviations from it, right? I've kind of given the AI a license to do derivative works from it. And then it's a question of, did you need AI to do it, right? Because if you had an original artwork that you created without AI, and then you created a derivative of it, or had AI create a derivative of it, it's an element of what is, are we trying to register the derivative? You can definitely register the original, right? And then if the derivative is original enough by itself, despite the fact that it's based on the original work, then you can also register it. But the general rule, and there hasn't been many cases yet, I think there's been like 5 or 4 applications with Copyright Office throughout the past year that have tried to apply, register some AI work. The general instances, if you wanted to go through this claim, right? And it's the same approach as, whenever you're a developer and you use open source software to create your app, you will not get protection for something that is open source, for something that is in public domain. You will only get protection for the elements of it that you have independently created. But this is that kind of like that nitty gritty discussion of like how involved were you in the AI generation process. That is something that creates that ad hoc of Copyright Office is going to determine it in each individual instance based on the specific case, which is not necessarily something new. They've always been doing it like that, right? Like you get a case, Copyright Office gets an application, they look at what the people have submitted, and then they decide, do they want to ask additional questions or do they want to let it through the registration? So it's, the kind of rule of thumb is if you have something that you haven't created, whether it was created by AI or just some other person, just claim it. That's kind of the general rule.
Okay, so we're kind of running a little bit of time. I noticed there are still several questions. We will pick the last one.
I have some time.
Okay, great. Thanks for Alex for your generous. So Jill mentioned her friend who is also an artist, and she posted her image on social media, and then it was being stolen and used by a large retailer. For example, let's say retailer might be Shane. And so what are the steps do you think like the artist should take, regarding the situation?
Also, if there is a case of copyright infringement, right, the steps are you do go to the Copyright Office and you register the copyright, because that will allow you to have the leverage of, having a good chance at avoiding court, right? And this is important because, one thing is the legal claim that you have and the legal ground that you have. The other thing is, if you're an individual artist trying to fight against, a big enterprise, it oftentimes is going to become a battle of wallets, right? Who has the money to pay the attorneys the longest? Because, let me give you an example. I've been, we had a litigation, it was trademark litigation, but for the past year. Despite the fact that we were on a defensive side, the sole, fact that we needed to respond to motions and replies and all of that cost the client, up to $100,000. And that just, with us being as generous and discounting as much as possible, just because it is a lot of work. So when it comes to those kind of instances, you want to register the copyrights, you want to make sure to have an attorney prepare a demand letter. My general rule of thumb on those instances is to make it as extensive as possible. It's kind of like you're preparing a mini complaint. Have all the exhibits there. Have it be a very, very detailed one, so to say, to make sure that you identify to the other party that you're serious about this, and that if need be, you will take it to court. Even though my general rule is, if I can avoid court and get a settlement, I'd rather do that than spend a lot of my clients' money, to get a judgment. Now, if you can see that there is a lot of value to be had from court, meaning, or the artist can see that there is a lot of value, meaning, oh, you can see that they've been selling those products and they're going off, and there's a bunch of different, revenues associated with it and potential damages, then it becomes, a little more, valuable for you to actually proceed with litigation. But originally, the first instance is usually that demand letter, kind of format. And if you don't have copyright registration, or at least copyright application, if the other side has attorneys on their team, they're just gonna, shrug their shoulders and say, well, you can't even sue us. Why should we acknowledge this, inquiry, so to say? In some other instances, if, for instance, somebody is distributing your content online, meaning something that belongs to you, but they're distributing it online, this is where DMCA takedown notice comes into play, and this is the Digital Millennium Copyright Act notice. It has its limits in terms of its applicability, but if you see somebody online posting something that belongs to you, that website usually has, every single website usually has a takedown process where you can inform their DMCA agent. And if you're building a project that allows anybody to upload anything on it, you need to have a copyright policy and a DMCA agent registration, because that is the thing that prevents users from being able to sue platforms for other users posting things on them. Otherwise, there would be no internet, because YouTube would have to monitor every single video before it's posted as to whether it has anything infringing, right? And you never know whether something is infringing or not. There's not a single database of things. So this is the system, the takedown notice, that allows you to issue a takedown notice, receive, get the work taken down. After that, the internet service provider, the platform, needs to reach out to the person infringing, and they have a chance to submit their counter notice, right? So you can get the work restored. And if you don't go to court after that, then the work does get restored. But at the very least, there are some ways to use the administrative process and reach out to the hosts of the websites, for instance, to take the website down for infringing activity. But generally speaking, it's there needs to be a certain level of preparation and your readiness to go to court, even if you are trying with all your might to settle this out of court. But you can't kind of half-ass it in the process. You need to go all in. Whether it be in the format of that demand letter, outreach, using attorneys, just to kind of get your position to as much leverage as possible to get your fair compensation without having to spend $100,000 to get it. So.
Wonderful. So regarding infringement, there is another question from the artist. It's more like self-awareness. Is this artist Barbara is asking, if we incorporate a magazine or printed images in a collage, in a much bigger work, are we infringing someone else's IP on this case?
I'm not sure I get the full context here. So when you're putting together a collage of images, are you infringing on somebody else's IP? Well, so whenever you use somebody else's intellectual property to commercialize it, to monetize it, right? It depends on what you do with it, right? At the end of the day, if this is meant for the purposes of an art and it's transformative enough, right? It's not just you putting one Banksy picture with another Banksy picture, right? And then being kind of like, oh, I want to print t-shirts with those two things together, right? If you're doing that, you're doing similarly to what you mentioned, right? But you are clearly infringing if you're selling those t-shirts. Now, if you're doing this for the art purposes and you're not necessarily monetizing it, anytime there's monetization, there needs to be a license. And yeah, I would say that the specific context kind of requires a little bit more of an in-depth analysis. Like, are we changing the medium in which those works were originally perceived? Are you making an audio-visual thing from something that were originally only visual? Are you making an NFT? Well, and it wouldn't necessarily change things, but how transformative is what it is that you're trying to do, and what is the purpose for which you are using it? If it's just here's my work and it's educational and that's just it, and me being inspired by things, okay, that's good. But if you are out there actively commercializing something that contains other people's IP, then there is a chance that they're going to have an issue with it because you're not paying them. So it just depends on the specific circumstances of the matter.
Yeah, I think
Alex.
Yeah,
I'm sorry. This is
go.
No,
go
yeah,
ahead,
I was
Barbara.
just.
Yeah.
Thank you. No, I was just thinking like if you were getting like elements of an image, like in a magazine. So there's a bigger picture, you're cutting out a flower, and then you're incorporating into like, let's say, a painting. So it's kind of like a mixed media. Does that, I mean, I see other people do it, and then I was like, well, I'd like to try it, but I understand, the basics of copyright and stuff. And it's like, well, am I infringing on the rights, or am I changing it enough? So it's just knowing what can I do, or I mean, I don't even need to go there because I just know I'm infringing on someone else's right. But I'm thinking of 2D, like a painting, where you're incorporating images.
Truth be
Elements
told,
of
truth be told, it would be good for, feel free to use the QR code, right? And kind of schedule a call for us to chat. I'll be happy to take a look at things, right? And kind of see what it is exactly that you have in place.
Yeah.
But the rule, one of the rules, right, generally speaking, is if a lot of people do it, doesn't necessarily mean that it's legal, right? That's one of those things. And then also is what it is, even if you do something illegal, that doesn't necessarily always mean that people are going to go and, hunt you down, because some people might not recognize the rose that you're using inside of that, from that magazine or whatnot, right? That flower. And if you're not commercially exploiting it either, well, then that also is an additional element that there's no damages to be had. So just a couple of different kind of like things that need to be accounted for. But yeah, feel free to book a call. Happy to chat.
Okay, thank you. I appreciate that. Thank you, Patty. Thank you, Alex.
Wonderful. So, Alex, I do want to close our today's webinar with the one last question. So for artist creator here, or probably going to watch this recording, what suggestions you have for them, to help them to avoid some common mistakes they might make regarding IP protection or infringement?
Well, truth be told, I think one of the most basic rules that I haven't had a chance to speak on today, that is very important for every creative, and every entrepreneur, is if you want to have your art be your business, meaning the thing that brings you money, treat it as a business, which means execute, not only, execute contracts and do all of that, perform registrations, but also open up a company, get yourself an LLC. Get yourself an LLC, because the name of the game is limited liability company. The idea here is that if you are operating your business on behalf of your LLC, if you have properly structured contracts that assign the IP from the people that you hire to create something to the LLC, if the LLC is the company that is on the website where you're distributing your work, if the LLC owns the trademark under which you're distributing your work, then a good protection is provided to you by the fact that, well, if somebody sues the LLC, the most they can get from the LLC is the money that is in an LLC's bank account. So that allows you to protect your personal property, your mortgage, your car, your house, whatever the case may be, if you are, properly organized, and if you are not, using your LLC for, fraudulent things to avoid taxes, etc. If you're not using it for the alter ego, if you're actually running it as a business, and if you're actually executing contracts on behalf of the LLC and doing registrations on behalf of the LLC and getting money to the LLC's bank account with a separate EIN number, like think of it as this SSN number for a business, and opening up an LLC and getting an EIN number and opening a bank account is something that you can do for $200 in any state using the website of a registered agent in 2 or 3 days. You don't need a lawyer for that. Just, there's a 5-3-step process. If anything, once again, feel free to schedule a call, I'll tell you how to do it. It's one of those things that I tell my clients to do themselves, because, if anything, there's no reason for you to pay me however much money to do this if you can do it yourself in 20 minutes. But LLC is very important in protecting yourself from liability if you are kind of figuring out, your approach to different people's IP, so to say. So.
Wonderful, wonderful. So, Alex, I really like your last comment to say, like, you know, if you really want to be a serious artist to make money out of it, treat it as doing business. That's also kind of a line when we host this kind of educational webinars and sessions for our artists as well. So, thanks, Alex, for having this, you know, very comprehensive webinar with us. I have dropped his contact information, and feel free to schedule an individual call with him. And thanks to everyone who's staying with us. We kind of overrun today, but apparently everyone have a lot of questions. Feel free to drop a message. Alex is amazing, and I think he is very happy to answer any question you might have. Thank you again, and see you next time.